I'm guessing you have some kind of family structure that is different than just a husband and wife and joint children. And that's really what we're talking about, a unique family structure. And I'll say lawyers put labels on things because it helps us identify things quickly. So when we say blended, we attorneys kind of understand what that means. I just want to make sure it's not confusing. And there's so many different types of blended family structures. You can see here, there can be something very common that we see. It's more like the Brady Bunch. All right. So children, husband and wife either remarry or a spouse has passed away and they have kids from those prior relationships and marriages. And they're of similar age, like the kids were in the Brady Bunch, right? Similar ages. Again, each spouse could have different priorities. Is it to provide more, for the children? Is it to continue to support the spouse? If you leave it all to the spouse, we're going to be talking about some strategies of maybe controlling some of that for the future to make sure that it gets down to your own children, especially when it comes to maybe separate property that you've inherited and making sure that it passes in the right direction. So I want to put this up here. This is our disclaimer for Cunningham Legal. You're going to be hearing a lot of information today. It is not to be considered legal advice. I just want to make that clear. Legal advice is when you come to us, we talk about your unique situation and your family concerns, and we're planning specifically for you. So I hope you get some ideas from this and get things churning, but please don't go out and do a bunch of stuff because you've seen this webinar. A little bit about our firm, Cunningham Legal. We're a California-based firm specializing in estate planning, trust administration, probate, and business law. I am a managing partner here at Cunningham Legal, and Jim Cunningham is our founder. Rochelle Lee Warner is another partner at this firm, and here are our attorneys, all practicing in these multiple areas. We really focus in on, thank you. We really focus on this area of law. So estate planning, and specifically today, we're covering the blended families and second marriages. I'm gathering that's why you're here. You had an interest in that. All right, so I want to start off by doing some definitions, talking about your family structures and what kind of piqued your interest to join me today. When you inherit property, we'll talk a little bit about the character of that property, and then it might be your separate property. Again, what are the ways you can ensure that that's going to get down to maybe just your children, or perhaps if you have a child together, to a joint child? You can see this is really complex planning, blended families. So I want to put that out there to know so that it is very unique with each family that comes in here. And we have a large population in the United States of blended families because, divorce is still at a 50% rate. And even after death, a lot of spouses remarry, okay? Or just have children from prior relationships that are coming into the family, whether they're adopted or not. So it is extremely complex when we're going through this, and that's, I think, why you're here. What can you put on top of your mind when you're meeting with an attorney? Other examples of blended families are varying ages. Now, I do see this quite a bit. One spouse has adult children from, a prior marriage or prior relationship, and they themselves, those children are grown. They might have children of their own, so there are actually already grandchildren. Spouse remarries, and they might have a joint children now with a younger spouse. Priorities here and the balancing of support is very complex. Do you want to give priority to that younger child because you want them to have the same benefits of the older children that are now grown and on their own? And then what does that feel like for the older children, right? When you pass away and maybe they've been left nothing. So I think there's definitely some balancing in emotions, believe it or not. When you pass away, it might be during your lifetime, things are going very smoothly and everybody gets along, and your older children or your other children get along with your new spouse. But I can tell you that once you're gone, there is definitely a shift. There's a shift in emotions. And we really want to try to be as cooperative as possible after that happens to make sure there's not going to be, a complete fight and put your spouse under stress and pressure by, outside children because maybe they weren't left on anything and their feelings are hurt. It's emotional, right? When you lose a parent. So I have had many clients I planned with where we talk through these strategies. And just remember, children, they have rights too. And without a good plan, they can come back into the picture after death and they can take something from your spouse. I mean, if that's not what you want them to do, you really got to get a plan in place. It's so important for blended families because you are in such a unique family position. It's not always divorce that's going to trigger that new family structure like we talked about. It's very common for widows to remarry and they're blending in families. We did have an elderly client, 87 years old, was widowed, and ended up moving into assisted living and found a new love and ended up getting, married and finding love again. And that can be complicated when you're blending assets. And you can imagine the way that their children feel when something like that happens. There's a lot of apprehension. Inheritance rights to married spouses don't vary, right? Depending on how long you've been married, and whether it's 50 years, it's 2 years, it's 1 year, they're going to have rights as a spouse. So it's important to keep that in mind. And that really, without a plan, can really go in the wrong direction. It's very important to get a plan in place. A new spouse in this situation still has that right to inherit, right? Through the probate code, they do. And if they've been, left out of the documents that are already been created, they still have a right to come back because they're a spouse. So we're going to talk a little bit about that as well. So examples of blended families. Some people, a little bit different than what we see with marriage, but some people have lived with their significant other, for 20 years or more, and maybe they have kids together. Okay. Maybe they have separate kids and they have some joint children. This can get extremely complicated because there might not be rights under California law for them to be able to share in the assets. So we do see things sometimes go in the wrong direction and maybe not what was the intent of a client because they didn't do proper planning. All right. So was that house actually held, one spouse's name, and by passing away, it totally bypassed their significant other, that although they've been living together for all these years, they're actually not legally married. And a lot of people throw out like, oh, in the community property marriage, aren't they considered married? No, they're not. All right. So that does not work. And so that house could go to the children, and essentially that spouse is out of luck and is probably going to have to leave that house and could be kicked out of that house. Do you want to give them some rights, a life estate, something to live in that house when you pass? So all these considerations got to be talked through with an attorney and see what's fair and what, the balancing of kids versus spouse and how you want to provide for them. So this is a little bit of a dangerous situation when you're not married at all because the rights aren't there under California law. Also, there are some tax advantages, of course, of being married, especially in taxable estates. So we want to talk through that when you come in and go through what really is it beneficial now to maybe get married and what is the hesitancy towards that? Because as attorneys, we are constantly thinking about tax benefits. So we kind of talked through this a little bit about the examples of blended families and having these clients that, have been married for a long period of time, but maybe aren't really treating each other like they're married. All right. So like we said, there's tax benefits to being married. So sometimes people completely separate and have lived apart for 20 years, even though they've been married for a long period of time. And they might have significant others, okay, in their own lives, but there's lots of good reasons to stay married for many different reasons. Now we've got a complicated estate plan because they might be living with their significant others in different properties. Again, everyone gets along, children all understand what's happening, no secrets here. But how are we providing now for those significant others versus what are the rights of the actual spouse? Because they are still married in the eyes of the law, and everything they've acquired and that their income, everything during marriage has to go to that community spouse, right? They have rights to that. So this is a really interesting scenario. I've had this where all four come in and we talk, and we're talking through all the multiple properties they all own together. Again, very complicated when it comes to co-ownership. with people and significant others that maybe aren't the spouse, and was the community property right to that house. So super in-depth, unique planning when it comes to those kind of complicated situations. Okay, worst case scenario, and let's be honest, is inheriting with no plan. If you're sitting here today and you have nothing set up at this moment, and you're kind of holding everything jointly with a spouse or a significant other you have children with, or whatever it might be, boy, this could be like the worst thing for you. And as far as we know, the death rate is 100%. We're guaranteed to die, right? This is not a guessing game. We will die. And we don't want to go into that with no plan. You have to think about how much that's going to cost your estate, whether things are going in the right direction. And then who do you really want to have in charge of your assets and control? And it says here, we're talking about when you pass away, where that is going with no plan, and who do you want to have in charge? The choice of a trustee, right? In your trust. Is it, what are the pros and cons of it being the spouse versus your child if it's separate property assets? So I hope today we cover that and get a little bit more stirring on your choices. The no plan means probate. And, you probably heard probate, you've heard how it's horrible, but I'll just reemphasize, probate is really expensive. All of the fees are set by the probate code. It's not like you can shop around to attorney and choose those fees. So it's going to be set. It's very expensive. On $1 million estate, you're looking at least $50,000 going out, which of course could have been saved by just setting up a trust and an estate plan at a very minimal cost as compared to that $50,000. But kind of worse than that is control, especially for a blended family. You're not getting to control where assets go and what your children get versus your spouse versus maybe a previous spouse that's still named on some of your assets. And so it's the control mechanism is huge when it comes to probate. So very expensive. Of course, it's a public proceeding. So you've got, people out there, predators that can see who's inheriting what and what kind of, they have people they can go after. It's just nobody wants things to be public, right? So a plan's going to keep it private. Probates also in California are taking a really long time. So at least 16 months. I mean, we've seen them out as long as 2 or 3 years. So it's just, especially with blended families, that they fight and they're all putting in their own petitions and I want to be in charge and this asset shouldn't go there. And so blended families can be a lot longer if things go through probate. So really important to get a plan in place. In probate, okay, and in a trust and in your planning, the characterization of the assets is key. Right? Because everything that you had prior to marriage, everything that you inherit after marriage, all right, that's all what we call separate property. So typically they're coming into a marriage, they already have homes, they already have some retirement, some bank accounts. Prior to marriage, that's all separated, okay? Once you get married, though, everything changes, especially in California, community property state. And everything acquired during marriage is called community property. So any real property, personal property, of course, debt acquired during marriage, you share that together. And what we typically see sometimes with blended families, and not even blended families, every family, is that they commingle the assets. It's really hard to trace it as to who owns what. And in blended families, that's really complicated, because kids might think they have an inheritance or a right to something you inherited from the grandparent down your own family chain, and it might be going a different direction into the new spouse's children, right? So if it was commingled and names were thrown on it and it was transmuted into community property, we have a problem controlling that later down the line when things are distributed, especially if something's going through probate. All right, so if a spouse passes away, keep in mind it is the surviving spouse that has, priority of rights in a community property state. It's going to depend on, though, which one of them have children, right? Maybe only one has children, and how many children they have. That's gonna, create a different kind of division of distribution of assets. If you have more than one child, 2 children, 3 children, 4 children, you're going to see that the character of the property matters, and then that dictates the distribution to spouse versus children. So characterization of property continues to be a priority. Inheriting money with no plan, like we talked about, if there's no plan, there's still rights for both the spouse, the kids, and other descendants. It gets really messy. We really have to focus on getting a plan in place. It's going to take a really long time for something to go through probate. So survivor spouses, like we talked about, if they are deceased, if their spouse has passed away and there's no descendants or children of their own, then the surviving spouse is always going to be in that priority position too and entitled to the entire estate. If they have one child, right, then the surviving spouse is going to get all the community property, okay, and half of the separate property. That could be something that maybe that spouse didn't want, but that's what the probate code says. Maybe they would have liked, their portion of the community property to actually get over to their child or be reserved for the spouse during their lifetime, providing income that ultimately get to their child. But that's not what happens under the probate code when there's no plan and you haven't put anything in place. If it's community property, it's all going to sweep over to that surviving spouse and they can do whatever they want with it, right? They're going to create their own plan. It can go a different direction. And the kid's only getting half of the separate property. So you've got a ranch you inherited. Your intention was maybe for that to get down to your own child, but it's going to be split in half. It's going to go to your surviving spouse and to your child because you didn't have a plan in place. So you're relying on the probate code to tell everybody and the judge where is it going. Surviving spouse has rights. If the deceased spouse is survived by multiple children, so we've got more than one, then there's going to be a separation. The surviving spouse does get all of the community property, like we talked about, and then a third of the separate property. So each child gets a share and a take in the separate property. Again, you can see this is probably not what people want. They want more control, and you got to put some thought and some intention into your planning. So example that we have up here is Mark has a property he inherited that provides most of their income that they're living off of. It's a separate property asset. He inherited it from his parents. Maybe it's been passed down for generations for generations. If it's taken through a probate and he has 3 children, right? His wife's going to receive a third of the separate property asset, which would likely result in loss of income, right? So during their lifetime, all of the income she was enjoying with her spouse, and as soon as spouse passes away, we lost 2/3 of the income. So we've got a plan for that. That's putting the spouse in a really difficult position to continue living off of, the same amount of wealth that they were receiving during life. What if he sold his home prior to the marriage? So it was separate property. He purchased a house prior to marriage and sold that home and purchased a marital home together with the new spouse. But he never put the wife on title. Okay. His children have a claim to the property. Okay. Where he would have preferred maybe to allow the spouse to live in it for maybe her lifetime. That's not going to happen. It's going to completely bypass spouse and it's all going to go to the children. So you can see this goes in a totally different direction, not as planned when it comes to blended families because of the characterization of property, how things are titled. So it's really dangerous not to have a plan. Another example of this going the wrong way, if Mark created a will, and just to kind of go back through that, a will does not avoid probate. It's not probate avoidance technique. A will always means we're in probate court. You have to have a trust to avoid probate. So if Mark only created a will, and he's attempting to give away more than his half of community property in that will to his kids, that wife is going to have a right to choose, right? She's entitled to, that community property interest. So sure, she could take half of the community property interest, but she's getting this choice to basically take what was given in the will or take more. So you got to be really careful in making these plans and knowing that this is going through probate anyways. So this could be really bad. Here's another example. What if Mark completely omitted the spouse from the old trust? All right. Never got around to updating the documents, got remarried, had a trust prior, and just never went back in and updated that trust to mention I've got a new spouse and I'm not providing for them, or I am providing for them, whichever it might be. So that new spouse will be categorized as what we call an omitted heir, right? She has a right to take it. She has a right to the title, but we never mentioned her in the last trust. she can jump into that trust and she can take her fair share of that separate property. That's a big deal. So if you have documents and you have a trust and you've remarried and you're thinking it's a separate property trust, I created it before marriage, it's going to go the way I want it to, you should probably come in and have that updated and taken a look at, because you need to mention the new spouse and what your intention are for providing for them, because they can jump right back into that and take a third of that share if you've got multiple kids, maybe half if you've got one kid. So really important to update your estate plan if you already have one. What about that ex-spouse, the one that you're married to before? I see this constantly with not updating beneficiary designation forms. So on life insurance policies or on accounts, there could be somebody, your ex-spouse named as the beneficiary on there. Well, then it's a race. It's a beneficiary race to each of the institutions. And even if a divorce decree says, hey, they get nothing, well, if the spouse's name is still listed on there, and they move in quickly, they're going to pick up that life insurance policy or that bank account and they're going to take it. So you can see, again, your life changes, right? You're going to have different spouses, more children. You have to constantly keep up with that change when it comes to your estate plan. So be really careful on this. Double check title, your PODs or TODs, anything jointly held if you're remarried, and make sure that you've got the right people named on there. So now we're getting to some solutions. So you can see there's a lot of red flags in planning in these unique situations. So what can you do as a blended family? Well, it's fairly simple, right? You need to create a living trust and you need to move your assets into the trust. If you have an existing trust, you probably need to get that updated and looked at to make sure you've mentioned your new spouse and you basically said they're disinherited or what they're receiving, right? Make sure that they're not considered an omitted heir and they're not going to take a piece in that. So a trust avoids probate in California. It's really important. There's other reasons why we have trusts. They protect us from a lot of other things, including Medi-Cal recovery in California. So you create this trust. You are the grantor or the creator. You are also the manager and trustee, all right? And you're creating it for your benefit. So you are also the beneficiary. We always see those three roles when it comes to a trust. This is difficult planning. We are, as attorneys, always balancing the goals of our clients. It's more important when it comes into these blended families because they are balancing their children and past children, maybe joint children, and the spouse's interests. There could be hostility with a new spouse. I can't tell you how many times a spouse has said, oh, those kids, my children from a prior marriage don't even talk to me. Like it says here, out of sight, out of mind. They're thinking, I don't even need to mention them. No, because they have rights. You've got to mention them and decide what you're leaving them. Are you disinheriting them? How are we providing for them? And are they going to come back and attack that trust? Large age difference between sets of children. This takes some special consideration. And again, have we provided for the older children throughout their lifetime? Have they gotten what they need for support? And are we now focusing on the younger generation to make sure they're getting that same benefit? Right? And so it could be that, there's a sub-trust set up for that child, but we can still control the distribution at a certain age, okay? Or upon the death of that younger child. So a lot of times a common trust might be set up for the younger kids, and upon reaching the age of 21, 25, and they've been fully supported, just like the older children, maybe at that point, there's actually a distribution out to the older kids and to the younger kids to equalize. Lots of thought has to go into this. And supporting that spouse that is, maybe they're the person that's staying home and taking care of that child. Maybe that child has special needs. Maybe they're going to need more funding. All of that has to be considered when you have children of different ages. This is interesting, little age difference between the children and the new spouse. I mention this because this is actually really common with me. The new spouse comes in and sometimes they're younger than your children from a prior relationship, and that really does cause a lot of conflict. There's also some tax laws in regards to rolling over IRAs and retirement plans that might be affected by that spouse being that young that we need to talk about and dig into. So a living trust, what does it cover? It covers what you put into it, okay? So here's this beautiful trust you might have created. Has it been funded? What have you put into that trust? So again, really important to be retitling your assets, make sure they're controlled by the trust. The terms then are going to control how that property is distributed and who is in charge of it. The trustee has 100% control. Now, the assets that are sitting outside the trust, life insurance, annuities, IRAs, 401ks, all the retirement, okay, it could be, pension, whatever it might be. These are outside your trust and they're going to go according to a designation on them. So a TOD, a POD, I'm sure when you signed up for your 401k, you filled out a beneficiary designation form. Again, that's controlled by the beneficiary. Can't do anything about it if it's not pointed to the trust. Okay, and we can talk about whether that's necessary, or we haven't done some planning on that IRA to see if maybe it should have been partially to spouse, partially to kids. How are we offsetting maybe prior kids from prior marriages? But beneficiary 100% controls those things versus what's in the trust. Trustee gets to control it. So take a look at your assets, see where they're titled, and let's make sure that you're funding your trust with those assets. So we create this trust. We're going to be really careful to fund it. We're going to put especially our real estate in there. That's a big red flag. Got to be in the trust. LLC interest, business interest, investments, cash, bonds, stocks, most things are going to be titled over there in trust, or at least pointed to the trust by beneficiary designation form. So I want to go over a little bit of different structure for a blended family. Blended families typically want a little bit more control after the first spouse dies, right? You can create a joint trust with your spouse. You can put separate property and community property into that trust. It's not changing the character of that property when we put it into a joint trust. Okay, so you can put your inherited property into that trust. It's fine. And then we want the trust to control what's going to happen to that upon your death. Typically, that means at first death, there's some work to be done. We're going to split the assets in accordance with the trust terms, and there's going to be a control trust that is created, a lot of times called a marital trust. Sometimes we have a bypass trust, has more to do with estate tax planning if you have a taxable estate. But a control trust typically might hold your 50% share of the community property and all of your separate property. Or maybe we don't do that. Maybe you're just thinking, really, it's just this one property. I want to make sure it gets over to, my spouse for life into this control trust. So they get income their whole life. And then ultimately the beneficiaries can never be changed. It's an irrevocable trust. So when my spouse dies, it has to go to my children. All right. So again, very unique, have to talk through every asset and decide, do we want a control trust? And then once we have provided for a control trust, who's going to be in charge of it? Is it going to be your spouse? Is it going to be your spouse and one of your other children from the prior relationship? Does it bypass spouse and we're just going to let our other kids control it for the benefit of the spouse? Okay, so a little bit more oversight. And those are really important discussion topics. Even in our other documents for incapacity, right? Who's going to be controlling my assets? Who's going to be trustee of these trusts when we both die? Is it one from each side of the family? Does that not work? Do we need a fiduciary because we want to avoid fighting? And there's a lot of different discussions that come into the controller of your trust, your main trust, maybe the marital trust, and then at death. So really, these are huge decisions you'll be making. This type of control trust, the marital trust, we refer to it as a Q-tip trust. Don't worry about the term. It has to do with taxes and qualifying it for an unlimited marital deduction. Because when you pass from spouse to spouse, there is no estate taxes. You get to unlimitedly pass from spouse to spouse and not worry about paying that death tax, but you still get to control it when the second spouse passes away. So it wasn't always like that. This is, something that came about because it was really unfortunate when one spouse would die and they'd have to sell everything to try to pay an estate tax. So it's a blessing. We can pass, from spouse to spouse without having that tax at first death. So in this type of control trust, we can make it as unique as you want it to be. It can sprinkle, it has to be all income to that spouse, and then it can sprinkle for health, education, maintenance, and support. But are there other provisions? Do we say you have to exhaust your own trust over on that side before you get to dip into this one for health, right? Upon remarriage, is there a change? Upon remarriage, maybe do the children of my prior marriage become trustee, so there's more control? Do we put a power of appointment for the spouse to be able to maybe slightly change the beneficiaries, but not away from my children, but in different percentages because they've done some lifetime gifting, or someone's become disabled and they have to create a special needs trust for them. There's all kinds of reasons why we might want to allow them to make somewhat of a change in the direction of where it's going. Ultimately, this marital trust, because it's irrevocable, it does have asset protection. And there is also a key to that being a huge benefit, having that control trust, not being able to get creditors into, because ultimately the spouse just has this income, right? So if there's creditors and debt sitting on the outside, they're not going to be able to come in and attack this marital trust to take it from your children, ultimately, when your current spouse passes away. So there's a lot of benefits to these control trusts. You can make them completely particular to your needs and to the assets you want placed in there. Another really common structure, still a control trust, is that you can see you created this joint trust during your lifetime. All your community property assets are in that trust. Maybe you also have separate trusts, okay, that were already created prior to marriage that we have to update and mention you're remarried and what we're doing with them. But maybe not. Maybe we throw everything into the joint trust, community property, separate property, and at the death of first spouse, essentially we say it pours over into two separate trusts. And I like this. It's very clean for administration purposes because it's going to divide the assets, community property and separate property. It's going to fund two separate trusts. That joint trust goes away. We never have to look at it again. Now we have two separate trusts, right? One for the deceased spouse's assets, one for the surviving spouse. They run their own administration. Maybe there's very clearly a different trustee over on the deceased spouse's side and a very clear line over for the surviving spouse where they can freely revoke and amend and make changes. What's beautiful about this is that at second death, we don't have to involve the other kids in the administration of the deceased spouse's trust, right? Our notices and our copies of the trust, it's just going to the beneficiaries that are listed over on this trust. It's a very clean administration without them having to communicate with each other and demand accountings and do all these things, okay? Because we've separated it. So it is a very beautiful way to structure and very common way to structure a blended family. So I'm bringing it up because it might be something that we discuss with you. It's called a joint pour over trust. Again, structure's pretty simplistic. For lifetime, a joint trust, but there's going to be a bit of a pour over when one spouse dies. And again, same terms, you can make that spouse to trust, however you would like it, right? It can have the terms we discussed with different trustees, exhaustion, remarriage provisions, and all of that can be built into that spouse to trust. And how your children inherit after that, again, I'm throwing this in because it gets you thinking. There's different ways your children can inherit when you both are passed away. Or if you're giving a specific gift out to your older children right away to kind of satisfy them, there's different ways you can give that too. It can be outright free of trust, meaning it just comes to them. It becomes part of their estate. The downside is it's subject to their creditors and divorce and everything else going on in their life. If you wanted to control it and maybe protect it, or at least give some added protection for them when they pass away and during their lifetime, you can give it to them within a continuing trust. So we're talking about the next generation of planning. Super useful for estate tax purposes. It's useful for protection from creditors, divorce. Gives a lot of flexibility if they're responsible, but we put them still in charge of their own subtrust. And you can see here, it can be a really beautiful structure for them. In particular, we'll talk a little bit about retirement plans and that kind of protection. Another type of trust we can create for your children once you both are gone is called a dole-it-out trust. A little bit different in this one. Typically, the beneficiary is not acting as their own manager of their subtrust or their trustee, right? We have somebody else, a sibling, a fiduciary, somebody else is acting as trustee because this type of beneficiary really shouldn't be controlling the assets. Either it could just be physically unable, all right, which might be more like a special needs trust, but it could just be they're not good with money. We're trying to make it last. And so we're going to allow a different independent trustee to dole it out a little bit at a time. Again, an irrevocable trust. It's got tons of protection from divorce, creditors, bankruptcy, all kinds of things, but still gives a stream of income and gives them support. So things to think about is now the next layer of planning. Okay, so for your loved ones. A trust protector is what we have in all of our trusts, because sometimes we have these continuing trusts for generations. Um, we want them to work. We want them to work without going to court and having to make changes that are very simplistic. So our firm, Cunningham Legal, sits in almost every one of our trusts as what's called a trust protector. I call it like a superhero power. We are not the trustee, so don't get that confused at all. We're not managing the assets. We're not watching, the people that created the trust, the grantors, and we're not watching the trustees. It means, though, after those grantors has passed away or if they're incapacitated, if something has changed out there in the world, which happens every day, tax laws change, a situation with your children change, maybe they're on Medi-Cal, maybe someone is disabled. It allows us to step in place of the court and make the change without getting approval from the court. It might mean beneficiaries have to agree. But if we run out of trustees, right, and this has been going on for generations, how do we get a new trustee in place? Well, the trust protector can just appoint that person. Might be a fiduciary. That a fiduciary is a private professional fiduciary in California. They're professional trustees. So licensed in California, you can meet with them, you can choose them, lots of options when it comes to trustees. But the trust protector becomes super valuable, taxable estates, but also just to make sure the trust is going to work, clean up ambiguities if there's ambiguities, right? A good example of this is, a property is placed into a trust and there's a specific gift that says, this is my separate property, it's property in California. I want it to go to my son Joe when I pass away. But during their lifetime, maybe that property got sold and that money was placed into a new property over in Texas, and the trust was never updated, right? So is that an ambiguity? If everyone agrees, can't we all understand and everyone understands that that separate property asset that was converted into a Texas property is supposed to go to my son Joe? Like, right? Those are the kind of ambiguities a trust protector can clean up in that circumstance with beneficiary approval. But those are the kind of things we're looking at. I mean, I would say people need to go in and look at their trust every 5 years, right? That is not happening as often as I would like it to. So the assets are changing and it's not matching what their trust said. So very important to come in and speak with someone. I'm going to dive into a big one when it comes to blended families, retirement accounts and IRAs. This tends to be one of the largest part of my clients' estates, and sometimes even more than their real property. Okay, and I know California real property is worth a lot, but typically people have more in their retirement accounts. So as the largest asset in their estate, you got to have some planning around that and potentially some control in a blended family. It could be this is the most significant part of your assets. So there has been quite a change in the treatment of IRAs since the Secure Act passed in 2019. There's been just a huge development. And I can tell you that when this got implemented in 2020, if you remember, there was a lot going on in 2020. I think nobody really realized that this got changed until a few years went by and they started realizing the results. So again, prior to the passage of the Secure Act, you could leave your retirement plans to your children and they could stretch it out for their lifetime, right? And there was this great advantage to that. This could be something that's passed on from generation to generation because they never have to take all the tax hit at once. And that law changed with the Secure Act. So in a typical situation, when a parent is passing an IRA down to a child, they're going to get 10 years to stretch it out. And then all will have to be cashed out. And they're going to take quite a huge hit on all the income tax that's owed on a traditional IRA. Remember that Roth is different because you prepay the tax on that. So with that aside, just understand the rules have really changed. There's some great exemptions we can use if you have a child or a grandchild that's disabled, chronically ill, special needs. What a great planning tool because they're an exemption to that 10-year rule. And we can really do some work with the IRAs to support them. And I'll talk a little bit about how I did that with a client. But you can plan in the trust, like we just talked about, to have these control mechanisms, maybe give specific gifts off the top as soon as you pass away to, your own children and the rest of spouse. There's lots of different ways to structure the trust. There is also some control mechanisms you can do outside of the trust. That can be through life insurance, okay, changing the beneficiaries of life insurance or getting a life insurance policy that just pays out to prior children, right? Or maybe a current young child to support them for life. Those are great opportunities, but the IRA itself is something when I'm looking at, we really need to figure out how we want to control it, if we want to control it. Because I think a lot of the times these are earned prior to marriage, and some of it was earned after, but everything prior to marriage was your separate property interest. So we've got a couple options when it comes to planning. We highly recommend, if you want control, to be using what we call an IRA legacy trust. It is a great tool for controlling your IRA upon your passing. Option one, of course, if you don't use a trust, you can just, you're naming beneficiaries on your retirement plans, and maybe it is 100% to spouse, but you have to realize if you do that, it goes to spouse. They're most likely going to roll it over to their own retirement plan, and they can change the beneficiaries, and it might not be your kids they're leaving it to. Okay, so if that's a really large asset of yours and you're wanting to do some planning, that's where you need to think it through. You can do different percentages. Maybe 50% goes to spouse, 50% to kids, or maybe we want more control and we're going to let the spouse have that 50%, do whatever they want to with it when they pass away, but we're going to control our 50%, maybe with an IRA trust. Okay, and the IRA trust is a beautiful way to control it for kids, to potentially get the stretch out, but also for income tax arbitrage and for control. If you have a beneficiary that really needs somebody else managing that, because what a lot of people do when they inherit a retirement, an IRA, is a lot of kids go in and say, great, I'm going to cash the whole thing out, right? Oh, $1 million, that'd be great. I want to buy a house, cash the whole thing out. So if they cash the whole IRA out, that is a huge income tax bill if they do something like that. They're not getting an advisement. There's no control. If you have the type of loved one you think is going to do something like that, but we would rather set them up for life with distributions, then we're talking about an IRA trust. That's how we would do it. So that's the ultimate control. Now, even if you want to leave it ultimately all to your children, but during your lifetime, you want to make sure if you pass away, your wife or your husband has that ongoing income support from your IRA, because that's what you've both been living off of, right, during your life. You can utilize this within an IRA trust, where 100% after you pass away goes into an IRA legacy trust. And it says, if I die, my spouse gets the benefit of it during their lifetime. They're going to continue to get the IRA stream. They can do a spousal rollover if they want, or just keep it the way it is. But they're going to continue to get the support, not have to take it out in 10 years. Okay, so for their lifetime, continue to get the support through your IRA, but we have controlled the ultimate beneficiary of that IRA through the IRA trust. So upon spouse's passing, whatever's left over is going to pass down to the next generation, to your children. It's a beautiful way to give your spouse what they might need during their lifetime, but ultimately control the distribution at their passing, so it's not, going in a different direction. So, and this is essentially a drawing of what it looks like. You pass away, your beneficiary designation form, again, instead of naming spouse first, it's going to name my IRA legacy trust. And so if you pass away, the IRA is going to dump into here. It's going to be controlled by the trustee of this trust, in making sure they're taking the RMDs that are required to be taken off a spouse's age or your age, depending on what route we go. And that's supporting them for their lifetime. And maybe the trust says they can take more if they need it for health, maintenance support, whatever it might be. We can make this trust whatever we want to make it. But ultimately, when the spouse passes away, it has to go to my 4 kids. That's control. And then those kids, we can make a decision about how they receive it. Do we keep it in the trust for those 10 years? Do they need, are they disabled or special needs? That's beautiful. We want to do a stretch out for their lifetime. So lots of options with an IRA legacy trust. It gives great control. This is just an example of all of the rules that came out after the Secure Act. There's so much that goes into us analyzing, who is qualified to receive it. Are they an exempt person? What's the best way to utilize this? Do they have to take on a 5-year rule or a 10-year rule? And so it's very, very dangerous not to be working with an attorney when you're making these choices, because if your IRA just designates it to your revocable living trust, a lot of times it's a 5-year stretch out instead of a 10-year. So you got to take all the income in 5 years if things aren't done properly and drafted properly. So it's I see this all the time when new clients come into me. We're talking about the IRA, how are things designated, and it's pointed to the revocable living trust. It makes me very nervous. Especially in blended families. We really want to map out control mechanisms and where we want it to go. You can see there's lots of rules attached to this, and what the payouts are. It's a huge income tax effect. We got to strategize and figure out what's going to be the best way to leave it. And you can see lots of strategies for minimizing that income tax. The IRA trust does that. This is an example where Bob's inheriting $2 million and without thinking he withdraws it. This is just demonstrating the insane amount of taxes he's going to be paying on the $2 million federal income, the net investment income tax, plus the state tax. And if it's a taxable estate, we're losing 40%, soon to be 50%, of estate taxes. So of the $2 million, he's only getting $118,000 after paying all those taxes. Not a good way to minimize taxes. So we might really want to control this. This is a great example, just generally, not just for blended families, for all of our loved ones that might be inheriting an IRA. I want to mention that for minor children, because I have 3 minor children, if they're named after my spouse as, the next 3, I have 3 children, beneficiaries on my IRA. If I don't have it set up in a way to be going to a trust if my husband and I passed away together, all right, it does mean a guardianship proceeding has to get started in court, and it's overseen by the court. And so a lot of times in these situations, we will set up an IRA trust to make sure it's controlled by the right people. We don't have to go through the court system to establish a guardianship. So it is something to think about. I do think it's somewhat rare for 2 spouses to pass away at the same time, but I think all of us with younger children, that's kind of a big fear for us, right? What's going to happen if we go on vacation and we're both kind of wiped out? So there is some consideration taken for all of you out there that if you have minor children and want to avoid that guardianship, we might want to strategize with an IRA trust anyways, so we don't have to go through the court system for control. And this is talking a little bit about that new 10-year payout rule under the Secure Act. It's no longer that longer stretch. And then, of course, after death, we have a lot of complex rules with the Secure Act and now Secure Act 2.0 that is, trying to guide us through what are the different rules for eligibility, what's the payout rules, who's eligible maybe to stretch it out longer. Again, surviving spouse gets that blessing, that exemption. If it's left to them, they get to keep going under their life expectancy. Eligible minor child. Okay, so if it is a minor child, they don't have to take it out in 10 years. They're going to let them wait till they're of majority age, then tack on the 10 years. If they go to college, they're going to extend it even a little bit further. So a little bit of a blessing for minor children. A person that's less than 10 years age. So I have some of my clients that leave it to siblings that are actually 10 years younger than them, and nieces and nephews, whoever it might be. So if they're within a 10-year gap, they actually get some of those stretch out rules, and we can talk about that strategy as well. Disabled, chronically ill person have a great opportunity to be receiving an IRA. Maybe they are receiving their share of the estate through an IRA instead of through the trust because they have such a beneficial income tax position to be receiving that way. So it could mean, because of the Secure Act, we need to restructure the trust entirely, because it might be so beneficial to leave the IRA to someone that's chronically ill, disabled, special needs than, over in the trust. And so we need to offset that and re-equalize. So we can basically not pay as much income tax for the other people that might be inheriting the IRA. So great things to consider. I'm going to roll into DSUEs. And so this is and portability. So essentially, I'm going to talk a little bit about taxable estates, and then we're going to open up for questions. But I wanted to touch on this because I have a lot of blended families that do have taxable estates, or are close and didn't even know they were close. And that is even more complex planning. So knowing you're a blended family and you have these, unique situations, we're discussing the IRA and control and who's controlling it. We're going through all these constant balancing, right? And then the next thing is, and we have a really large estate, we're going to have to pay 50% in estate taxes, right? Something really difficult to kind of plan through. So again, the federal exemption amount this year is $13.72 million. That's a lot of money per person. So if you're a married couple, you each get that. That's over 26 million. And we have clients over that, and we're really doing some structuring and planning for them. And one of the things to know is that number constantly changes. And that means the structure of a trust changes. And that means, our strategies change. And it means that, your estate could very well be susceptible to an estate tax in a couple years, and you might not have known that. So although it's over 13 million per person today, at the end of 2025, it is reverting back to old rules and is going to drop to 6 million, and with inflation, a little bit more, 6 million. So it's basically being cut in half per person. All right. So if your estate is going to be anywhere near 12 million or so, we've got some major planning to do if you're over that, if you're over 12 million, and even if you're close, because with appreciation, I am anticipating you will be paying an estate tax, which is really large. So what's so interesting is that you have this ability when one spouse dies to claim essentially the deceased spouse's exemption amount, whatever they haven't used. So that's the deceased spouse's unused exemption. We call it DSUE as attorneys. Now you can claim it either by putting it into one of those beautiful control trusts, right, which is wonderful estate tax planning. You can also claim it by filing a 706 and claiming the leftover through something called portability. And again, it's just a tax filing. And if you had a spouse die in the last 5 years and you did not claim portability, and you have a fairly large estate, going to be over 6 million, you need to call us. We need to file for portability before you lose that ability to file. They have extended the ability. Portability usually has to be filed within 9 months of date of death, but they've been generous in extending it to, within the last 5 years, you can file for portability. File for portability. Before you lose it, you claim your deceased spouse's federal exemption amount. I often refer to it as your death coupon. We all have a death coupon. You better claim it before you lose it. It'll be gone. So you either got to, again, claim it, or you got to put it into some type of irrevocable trust that's holding it for the benefit of spouse, maybe children. So when we're looking at this, this exemption amount, again, we refer to the dead spouse as deceased spouse, alive spouse as surviving spouse. A couple of things to remember is that for community property and anything earned during marriage, right, there's this step up in basis that occurs at first death and sometimes also at second death, depending on what kind of characterization is of the asset. There's a great benefit to getting that step up in basis. So if you purchased a property for 100,000, right, and this was your home as a community property asset, and it was going up in value during your marriage, and when the first spouse passed away, maybe it's worth $1 million. Okay, we've seen property grow, brokerage accounts grow. At that first date of death, if it's community property, the entire basis gets stepped up to those values. So $1 million. It gives a chance for that surviving spouse to maybe liquidize, sell that asset, and have zero gain. All right. If it's a community property asset and it continues to go up in value in the second spouse's lifetime, at the second death, it gets what's called a second step up in basis for the heirs. And again, gives a great blessing to either take that nice high basis or to sell and to avoid the capital gains. Separate property is handled a little bit differently. That's why in California, there is some tax planning of like, I don't want it to be a separate property because I want a double step up, because separate property only gets stepped up when the person that owns it dies, not when the spouse dies. And so there is a little bit of arbitrage that people do when they come in to recharacterize some property to get some tax advantages. So that's something to think about. That step up is really valuable. You still get that for the property that's placed over in that control trust, that marital trust. If we're not worried about taxes, it's still going to get that beautiful step up in basis with those community property funds that are put into there for control. That's an advantage ultimately for your kids when that passes to them, because they're going to get that uplift of basis and can make some choices with that asset. So again, really important to timely file that 706 for portability, that if a spouse has passed away, you've claimed that estate tax exclusion. Remarriage gets a little bit difficult when it comes to this. A surviving spouse is entitled to use the unused estate tax exclusion only of the most recent deceased spouse. So if you were married prior and you claimed portability, right, for your first spouse that passed away, and you remarry, it could be you're going to lose that. You're going to lose your first spouse's portability. There's also a great opportunity if you have a large estate, and I'm not encouraging you, to marry and then marry and marry and marry again, because that is a way to stack up exemptions. But essentially, you can gift your first spouse's exemption amount. All right. If you gift it all away, you've used theirs, and now when if your second spouse passes away, you also get theirs. So there is definitely some strategy sometimes when I get a taxable estate into my office and they had a previous spouse that died and the exemption was claimed in portability, we're doing some pretty heavy gifting strategies to gift maybe their $1 million exclusion, 6 million, whatever it was the year they died. We're going to gift it now. And that way, wow, we just got away with claiming, not losing 3 million in estate taxes on that later. And then when my second spouse dies, I get to claim it again. So there's definitely some strategies in maybe utilizing that first spouse's exemption amount if you claimed it. That's the key, right? But you just have to keep in mind, you don't get both upon death. If you didn't claim it and use it and gift it of the first spouse, it's gone. You're only going to get the second spouse's portability amount, which sometimes is not beneficial. So you can see that this requires a lot of tax planning if you have a taxable estate. And there is certainly some things for us to be looking at if you have an estate that large. I'm going to read through these really quick and then we can open for questions, but good planning here. The first wife dies in 2011. They leave it all to husband. Husband, portability is claimed. Good job. They filed that tax return. They remarry. And then during husband's lifetime, he gifts $13 million to an irrevocable trust for the kids using and porting the exemption. Maybe that husband gifts it to their new wife in an irrevocable trust that gives income for life, but then goes to kids. Lots of different ways to do this. Wife 2 dies. Well, husband loses whatever was left over in the portability from the first wife, but we gave a lot of it away. And now we can file and pick up wife's 2's exemption amount. Bad planning. Wife dies in 2011, leaves all to husband in portability's claim. Marry the second wife with a sizable estate, right? Marrying a second wife with a really large estate. A wife dies and leaves it all to her children, completely bypasses the spouse, which sometimes happens. I got nothing to port. All the exemption went to the kids, and now we're just kind of stuck with our own exemption, and we didn't get to utilize that first spouse's exemption amount. You see, there is just so much to this when it comes to taxes. All right, well, that's going to complete our estate planning for second marriages and blended families. I tried to talk as fast as possible. I apologize for that. A little bit about Cunningham Legal. We have office locations all over California. You can see them up here. We'd love to meet with you. If you need a consultation, give us a call. Also, if you're joining us right now on YouTube, please keep watching and it's going to roll over to the next video.